All right. All right. We're back. We're back. I made it. So welcome to what frankly is a rare Saturday stream. I don't tend to get on here on Saturday, so yeah. But the Karen Reed trial has kept me busy and I'm way behind on everything else that I've been covering. But this looked fun, so I said, screw it. Let's do it on Saturday because you know me, I like to have fun and if it amuses me, I'm more likely to cover it, and this amuses me. So, Paul, you kind of are. There were a few like last night before, like right when I created the stream, but you know, I still appreciate you rushing in before I got here. Same with 3 cents and SD. I don't know if you're in here yet because I noticed this a little while ago. But thank you for becoming a member. I've appreciated you having you in the chat. And Brandon, I wouldn't I wouldn't expect anything less. I mean, frankly, I tend to usually watch things on replay myself. That's why you rarely see me in other people's chats. So, Kova, always a pleasure. And Neil, I mean, being 3 or 4 minutes late, that's still early by Mormon Standard Time. So we're all good. Luna, always a pleasure. And um Kevin, is Bernie Sanders making an appearance? I doubt it, but we'll see. And Gia, always a pleasure. Say hello to Zoe for me. Menchie always says hello to a fellow corgi. And Vince, I realize the entire weekend at your parents' pool is important, but this should be fun. And Judy, good to see you. Dan, and SD, I guess I should have scrolled down, but thank you for becoming a member. West Side Girl, good to see you. So to Tooele, 40 minutes, 45 minutes to drive to Tooele, other side of the mountain. So yeah. And oh yeah, I guess Allie Benny, it's a rare Saturday afternoon stream for me. It's Sunday morning for you. So NRH, I'm pretty sure I've seen you not lurking before, but either way, and William and Wicket, corrections, Lisa, wonderful to see you all. Anyone who comes in later, lovely to have all of you here too. So I have a feeling, there's a pretty high probability that this stream gets me sued. The subject matter of this stream sues people. They seem to admire delete laws. They seem to love frivolous litigation. Everything I've seen them do has appeared frivolous. They aren't like they actually make delete laws look good at litigation, as hard as that is to believe. And I bet you can, Gray Duck. It's probably going to be one of those delete laws reverse class action situations. So yeah. And Neil, you're right, there is. I'll get to it, but because this one amused me so much, it jumped to the front of the queue. So as is my habit, when I'm covering a new case, when I'm covering a new subject, I introduce myself. And so I want to make it very easy for this woman to sue me. And I will give her a hint about Team Skeptic as well, because she has a habit of not serving people when she sues them. So, I want to make it real easy for her. So my name is Schlitzenheimer McGillicuddy, and I'm accepting service at 123 Fake Street. Just leave it on the table next to the fireworks. Now, as it would happen, Team Skeptic's name is also Schlitzenheimer McGillicuddy. It's a little known fact that we're actually twins. It just, we haven't told you all, but we're twins, and our parents were very uncreative. So they named us both Schlitzenheimer McGillicuddy, and he's also accepting service at 123 Fake Street. So even though our parents are uncreative, naming us both Schlitzenheimer, Team goes by Schlitzy, I go by Jaime. That's how you tell us apart. So yeah. And yeah. So she has been active in his comment section. This is a good chance to remind people that this is not a petting zoo. This is an animal safari. Keep your arms and legs inside the car at all times. Don't approach the subject of this video. Just point and laugh. Don't approach her. Don't contact her. Don't, obviously, if and when she comments on this video, laugh at her in my comment section. Give me the positive engagement. We'll obviously be seeing some of her contact details that she put into the public because she chose to sue. So we're looking at public documents that she put in public. She chose to drag Team Skeptic into court, kind of. Not the other way around. So she put her contact details out there, but we try not to put those on the screen. But either way, do not contact her. Do not contact her. So I invited Team Skeptic to join me on the stream today, but for some unforgivable reason, he seems to think that his pre-existing Father's Day plans with the family are more important than streaming with me. I don't understand it. It's It's wild to me putting family first. You know, my, I mean, he's my twin brother, and I'm not doing Father's Day until tomorrow. Um, but as punishment, and he might be, he might be in and out of the chat. He said if he has time, he'll listen along. But as punishment, I want you all, after this stream, to go to his most recent video and leave a comment saying Happy Father's Day, Schlitzy. It's that's not brigading, that's positive engagement. So yeah. So that all being said, SD raises the big question. Who is she? Well, she is an apparent sovereign citizen, just like Delete Laws claims she's a law student, and she lives in Michigan. She basically, Team Skeptic covered one of her court hearings in the Michigan state courts, not federal court. Federal isn't, streamed. And that's it. She was in court, lost her car, lost her house, made an ass out of herself in court, and Team Skeptic covered it a year ago. And she really doesn't like criticism, is what it looks like to me. So she sued, as is her general practice. And pretty much, just like Idaho is the Alabama of the West. So, like I said, I expect to be sued. But I will give her this warning. You won't win. You won't win. You're not going to win against Team Skeptic. Not going to happen. So what we're going to do is, first, we're going to watch Team Skeptic's video about her. Now, generally, when I watch court videos, it's to point and laugh at the antics of the person in court. Now, while there's a lot to point and laugh about, I am a lawyer. We aren't here just for the comedy. What we're here for is to do a legal analysis. So we're specifically paying attention to Team Skeptic to give an analysis of, has he done anything wrong? And I don't know that she's claimed a allodial title to anything, but yeah. And yeah, it's sovereign citizens don't believe in the law. The law doesn't apply to them, but by God, it applies to you, and they can use it against you. Doesn't make sense. But yeah, so we're specifically paying attention to Team Skeptic. Now, to the subject of the video, yes, I'm republishing Team Skeptic, but I'm doing it to provide commentary, a legal analysis of what Team Skeptic is doing. So I am not defaming you, just, friendly, warning. It's not defamation. Team Skeptic isn't defaming you either, but yeah. And so after that, though, we will look at the complaint, and we will also look at some of his some of her other frivolous lawsuits that she's done in the past. And I mean, see, I don't have to worry about fair use on this one necessarily because I mean, like, even if I played it straight through, I have a feeling Team Skeptic wouldn't strike me just because, you know, if I'm saving my commentary for the end, I, I think I'd be okay. You all know me. I can't save my commentary for the end, so I won't even try. But yeah. So I am reminded though, since a Lodial title was mentioned, she's not a Moor, but I have been saving something for my next Sovereign Citizen video. The I've just been, you know, occupied with the Karen Reed trial, and the time hasn't been right. But for those of you who have been watching the trial with me, you may remember way back, like first week of May, Law Talk with Mike popped in, and I was teasing him, and I said my parents were in Paris for the day on their way home from a vacation. And I didn't say where their vacation had been, just that Paris was their layover day on the way home. And that Mike would be very jealous of the souvenir they were bringing home for me. And Mike guessed that it was a, you know, a naughty Parisian mademoiselle, which I said wouldn't fit in the suitcase. But it's my parents and my sister and nephew and brother-in-law and brother-in-law's mom and aunt all went to Morocco, and doesn't fit over my headset, so I'm not going to wear it through the video. But I have a real Moroccan fez now. So the reality is, you know, the ones that Mike and Kfar and others bought on Amazon are probably higher quality, but they went to a museum in Pterodont. Can't remember what the museum is called. I'd have to look it up. But the staff was wearing fezes, and my dad said to them, "Oh, my son wants one." One of those, where, you know, is there a gift shop or something? And the museum employee ran back and grabbed the same fez that they were wearing. So, like I said, it's not the highest quality, but it's real Moroccan. It even it's lined with wrapping paper on the top, so you know it's a good one. But like I said, it's gonna fall off my head wearing it with headphones, but I now have a fez for Sovereign Citizen videos. So, I guess if we're all getting sued, delete funds may as well be here too. So is that all the prelude I needed? I think so. And Judy, that's actually funny story. So my brother-in-law's mother, while they were there, posted about the Treaty of Peace and Friendship on Facebook, because their driver had told them about it. Because, you know, the Moroccans are very proud of their close relationship with the U.S., you know, being the first nation to recognize the U.S. as an independent country. So the Moroccans are very proud of that. And so they were telling my parents and, you know, family about the Treaty of Peace and Friendship. And that really made me laugh. Really made me laugh that, you know, they're very proud of it, and you have these criminals co-opting it, and it's ridiculous. So, yeah. But let's jump to the video, see what Team Skeptic had to say a year ago. Yeah.
Welcome to today's video. Today, we have a crazy conspiracy Karen who threatens to sue the court.
Had it on 1 1/4 speed from watching the trial. So we don't need Team Skeptic to sound like a coked up chipmunk. Slow him down.
If they continue to prosecute her against her consent. So let's begin.
2300820M. This is Van Buren Township versus Lindsay Dineski.
Yes, ma'am. That's me. On behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
Yeah.
Studying to be a lawyer. So she doesn't need the court-appointed attorney. Well, studying to be a lawyer in sovereign citizen land doesn't mean going to law school. Now, before we listen to what Team Skeptic has to say, there's 2 things I noticed there. Number 1, it's, you know, the 9 in her Zoom name at the end. Is that a time, like the time she's scheduled, like just administrative for the court, or is it trying to do you know, UCC 9-109 or whatever they do from section 9? And yeah, it's boiling. I was really disappointed in Team Skeptic's video that it wasn't Lenka getting foreclosed, but she just causes other people to get foreclosed. But number 2, she says she's studying to be a lawyer, Vera. Not that she's in law school, but I don't know that she'd get into law school. So we've discussed before, getting into law school, you need to take a background check. Your criminal record can keep you out of law school, because law schools don't want to, you know, have you go to law school if you can't become a lawyer at the end. And so if the bar would reject you, the law school will reject you. Usually. There are exceptions, but generally you have to prove you're reformed and community-minded, and, you know, it's a big hassle, like, and rare. So one of the things the bar looks at is civil litigation as well. Because, you know, do you bounce around eviction to eviction? Are you being chased by collections? Are you know, they will look at, like, if she applied to law school, they'd look at all of this frivolous litigation in federal court, and I think the bar would turn her down based on that alone. Just based on that alone. And Judy, I have a feeling it's going better than Miss Dineski's bar studies. So, but let's listen to Team Skeptic.
I wouldn't call going through the junior college application process the same thing as studying to be a lawyer. The truth of the matter is, she's one of those pro se constitutional scholars like Chili DeCastro that think they know everything about anything and are prepared to change the entire system with just one functioning brain cell.
That being the case, have you had the opportunity to speak to?
So that was insulting. You know, we're analyzing Team Skeptic, his commentary. Of course, if I remember, one of her counts against him is like, you know, unauthorized publicity or something, whatever it's called. I can't remember. But playing her public court hearing doesn't count. What he said, what Team Skeptic said, is mean, but it's not defamation. Hyperbole isn't defamation, especially clear hyperbole. When he says one functioning brain cell, that's hyperbole. I know you guys know that, but for the benefit of the future lawsuit, it's hyperbole. It's not defamation. And the truth also is not defamation. So when he says she looks like one of those, you know, constitutionalist wannabe lawyers, whatever it was he said, it's not defamation because that's what it appears. That's truth.
Ms. Manarino this morning?
Yes. I
Ms.
think all
Manarino,
charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Retaliatory.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Danuski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial. But I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights.
Okay. When the options are take a plea or go to trial, anything other than take a plea is go to trial. So when you say, yeah, I want it dismissed, I demand it dismissed, because that doesn't put you in the I'm pleading guilty box, it goes in the we're going to trial box. You're requesting going to trial because that's the only mechanism to get it dismissed. So, yeah, but either way, it's still, well, exaggeration as in one too many, I assume is what you're going at. But yeah, file a motion. And it's her children. But, you know, retaliatory and violating several of her rights. Now, when you say it's violating several of my rights, that means nothing. That means absolutely nothing. When we look at the civil complaints, you're going to hear me use a phrase a lot that you've already heard me use a lot. But they're violating several of my rights is just a conclusory statement. It means nothing. It's, you know, in the law, saying they're violating my rights is just a conclusion. It's, you have to say they are violating my Fifth Amendment right against self-incrimination because I asked for a lawyer and while I was in custody and they kept asking me questions and pressured me into speaking. Therefore, the confession should be thrown out. The confession should be suppressed. And without the confession, they have no evidence. Therefore, the case should be dismissed. See, that's what lawyers do. Not they violated my rights. I know you guys know that. And yeah, it looks like so the 9, it is a time. So 9:30 a.m. for Kyle Sherline, 10 something, 9:10. So it is just time. So not sovereign citizen stuff.
Michigan and federal rights under the Constitution of both.
I thought you said you were studying to be a lawyer. Wouldn't one of the first things they teach you in law school is the difference between an arraignment and trial? One of those appearances are where you present evidence of your innocence, and the other is where you say guilty or not guilty. Care to try again?
Plea not guilty.
So Team's actually not necessarily right, because at least in my law school, criminal law was a second semester class. So first semester was civil procedure, contracts, torts, and writing. So constitutional law 1 and property and criminal law were second semester. Still first year, but second semester. And really, we learned about sort of the philosophy of criminal law first. We learned about mens rea and actus reus and levels of culpability and all that fun stuff.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money. But what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Tenesky, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, Nerswick.
I don't know that the charge was ever said in this video, so yeah.
ICK, do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which
Your
is
Honor.
what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, or I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well.
And I'm sure that
Okay. Couple problems there. So this arose out of a custody dispute because, as my regular viewers know, I often say there are 3 primary paths to becoming a sovereign citizen. Number 1 is taxes. You fall behind on taxes, and that's how you find the sovereign citizen tax gurus. Number 2 is you get your license suspended, and hey, someone tells you, well, you don't really need a license to drive. And number 3, though, is child custody. Those are the 3 primary paths to sovereign citizen. And yep, it's very close. So number 2, though, I'm already suing Van Buren Township, which I believe we will take a peek at that. But if this isn't dropped, I'm going to bring a malicious prosecution charge against this court. And we've looked in the past at what it takes to bring a malicious prosecution charge, and there's a condition precedent, meaning something has to happen before you can even bring the claim. And you have to have a successful resolution in your favor. Now, that doesn't mean you'd win, but you have to have that to even bring the claim. And not that I know of, not yet. So either the case has to be dismissed or she has to win at trial to even bring a malicious prosecution claim. But she can never bring it against the court because, well, frankly, the court has sovereign immunity, the judge has judicial immunity, but also they're not prosecuting her. Van Buren Township is prosecuting her. The prosecutor prosecutes, judge judges. It's that whole 3 separate branches of government. Judges don't prosecute. How many times have we heard sovereign citizens, you can't practice law from the bench, so if she's not practicing law from the bench, how can she be prosecuting you? But sounds like Miss studying to be a lawyer isn't very good at this, from what I see.
That's not the first time the court and its officers have been threatened to be sued by a petulant Neander Karen. At this point, I'm surprised someone hadn't sued Crayola for not having a dangers of brain damage label on their adult edible line. Which brings me to today's sponsor, Factor. Are you tired of eating?
All right. We're not going to listen to his Factor sponsorship. Of course, if the code is still good, support Team Skeptic with Factor. But once again, this is to the wannabe lawyer. That was parody. That was, well, not parody, but that wasn't defamation. He wasn't saying you are a Neander Karen. Because what is a Neander Karen? It's not defamation. It's not defamation. It's comedy. Comedy hurts, but it's comedy. So let's skip through Factor, and I think we'll go right about there.
Now, as you may have noticed, I don't take sponsorships that often on this channel because I'll only recommend a product that I both enjoy myself and I think you'll get a benefit from it too. So if you're like me...
And he does, but, he streams all day, every day. I'm trying not to turn this into a 9-hour stream. I talk enough on my own.
And you live on the go, but you don't like to eat like you live on the go? Then try out Factor. The link in the pinned comment and description will get you 50% off of your first order, and you can cancel at any time. So let's continue.
Because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court.
I know I said we're reacting to Team Skeptic, but I can't help myself. Number one, I still don't know how this is retaliatory, or as she says, retaliatory. It's not a violation of due process. I mean, like, unless there is a separate case that they're trying to pressure her over by charging her. But I don't see that. Due process, we always hear from sovereign citizens as they're getting pulled out of their car, I demand due process, due process. This is a due process violation. And the thing about due process is it's a process. So in court, due process at its most basic form is notice and an opportunity to respond. So, she's obviously had notice because she's here today, and she has an opportunity to respond because she's talking today. She's given the opportunity to defend herself. She's been offered a court-appointed attorney. It's where's the due process violation? It's and I often say with due process, yes, you are afforded due process. That's in the Constitution. But due process is not your process. So sovereign citizens want their process. But they don't get that. They don't get that. Until there's individual laws passed by the government for them, which they can't have, because frankly, I mean, I don't actually know if it benefited them, if that would be a bill of attainder. They don't exactly teach a lot about bills of attainder in law school just because they don't happen. So, but, I'm going to bring color of law lawsuits, and I assume by that she means 42 USC section 1983, deprivation of rights under color of law. But when you say, I'm going to bring a color of law lawsuit, that doesn't mean anything. It's, are you going to write it in Crayola? Are you, what? It doesn't mean anything. It doesn't mean anything. So, yeah. And Luna was the name. I don't know who that Luna is, but Luna, send $200. Ha ha ha. So, yeah, I don't know. Yeah, file an affidavit. That'll do it.
In federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law. I could quote laws that Van Buren police broke.
Well, I mean, just like the whole, several of my rights were violated. I could quote case law as if that's a threat, as it, here, have a cookie, have a gold star. I can quote case law. Whoop-de-fucking-do. Yeah. I could, but I won't because, it won't be correct. Without my conclusory statements, I have nothing. I have nothing. So no, we're all Schlitzenheimer McGillicuddies, You'll have to figure out your own unique identifiers off of that because, team is Schlitzy, I'm Jaime, start and end of Schlitzenheimer. And by the way, it was said at the beginning, that Schlitzenheimer McGillicuddy, great name. It's a decades old family joke. So
They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded.
Who said there was sexual discrimination against you?
I mean, it would really be a waste of the court's time.
I do not want to hear anything about wasting the court's time coming from you, Karen, especially when you have multiple frivolous lawsuits out against your husband and any law enforcement agency that doesn't enforce the law the way you want them to. In the description, I'll attach a rejected lawsuit where she accused several Greene County officers of not just running her off the road, but then immediately changing to help her as soon as she started recording them.
Like I said, we will also take a look at some of these lawsuits.
How convenient. She also accused them of the normal sovereign citizen violations, like deprivations of right under 18 U.S.C. 241 and 242.
18 U.S.C. 241 and 242, there is no private cause of action under that. That's criminal. Like literally anything you see 18 USC whatever is federal criminal law. Title 18 of the federal code is criminal law. So 18 USC 241 and 242 is criminal. It's criminal charges. You know who can bring those? The U.S. Attorney's Office, the Department of Justice, federal prosecutors. You can't sue under 18 USC anything. Like, you know, can't remember what the securities law violation is, 18 USC something, but if you're the victim of a Ponzi scheme, you can't sue under it. You have to sue under the civil securities laws. Civil, it's different. You know, you can't sue. I mean, this is a state claim, but you can't sue for, as Schrodinger's cat put it, the unauthorized use of another's body. You know, being forced into bad situations. On the other hand, you can sue for the, you know, battery, for, you know, that some states have laws, civil, for specific battery, trying to be vague, trying not to get demonetized. So yeah, it's, I didn't watch yours, Judy, but I might have seen that. And it really is the Uno reverse card. It's, you can't arrest me, I'm arresting you. And that doesn't work.
And not consenting to prosecution.
The one who broke the
Miss-
law was Van Buren Township, not myself.
Miss Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the
Yes,
first
but
appearance where
I
you
could ask for
respond.
it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren.
You got a PR bond. You got a PR bond. And I can ask for this to be dismissed at the arraignment. The problem with that is you don't present evidence at the arraignment. You present evidence at trial. Now, you can do a motion to dismiss, but the thing about motions to dismiss is they're written. you haven't done that. And yeah, by sovereign citizen logic, all he has to do is say, nope, don't consent. The law doesn't apply to me. And he's good. But the problem is with sovereign citizens, it's rules for thee, but not for me. And yeah.
Buren Township. His father used to be the fire, one of the high, like he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
You alleging that he has mental problems is conclusory. It's all conclusory. And there's bias because his dad is a firefighter. That's not bias. It's just not. It's just not.
I didn't think she'd ever shut up. And forgive me, Karen, but I'm not buying this story that the police arrested you simply because you asked them for help.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor.
That's a good point, Judge. This is being streamed on YouTube. So maybe don't say crazy stuff that will get people to make fun of you. Because people making fun of you when you say crazy stuff is not defamation. It's not defamation.
As it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes.
Wait. He kidnapped my children. Not my biological child. Did you adopt her? Like, is the child his biological child? Like, if you have no like legal tie to the child other than having been married or having dated the father, him taking custody of his own child is not kidnapping. You trying to take her would be. I'm not saying she did try to unlawfully take the child, but if it's his biological child and not yours, then you don't legally, you're not entitled to visitation or custody or anything.
Yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her.
It would be, but once again, this is in court, so maybe wouldn't be, but yeah, if she's trying to take the child that isn't hers, to me, it sounds like it would be kidnapping. And she's saying, I am her parent. That's not what it sounds like to me.
as he does as a biological parent.
Sorry, Karen, but unless you've actually adopted that child, which is a separate legal process itself, then you have no automatic rights to the biological child of another woman. Now, the courts can grant you visitation if the courts believe that it's in the best interest of the child. But just look at you. You're a conspiratorial nutjob that thinks the entire world is out to get you because you're not getting your way. And I would be befuddled to find out that the state thought that it was in the best interest of a rock to be put under your care.
The court.
So, not defamation from Team. It's the and she did say it's, you know, even though I'm not a biological parent, I still have the same rights as he does as a biological parent. Unless you adopted her, you don't. Period. Like wherever you're studying law, you're doing it wrong.
When gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court to as a shield to keep a mother away from a child.
So based on that, if the court had previously given the father custody of the child because it would be a two-parent home because she was with him as opposed to the biological mother, well, that doesn't give you rights to the child. It just means maybe the biological mother can come in and say, hey, the situation has changed. I should now have custody. You gave him custody based on these conditions. Those conditions no longer exist. Therefore, I am now better suited to be the primary guardian. So his relationship with the ex-wife, with the biological mother, has no bearing on what rights you have. Because you don't have any. At least not as far as the child goes. She's not your child. The only person with an argument about, oh, hey, they broke up, therefore custody shouldn't be with the father, is the biological mother. So, bad argument there.
And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her. And I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind due to the abuse and
all right, we have Saint Karen here.
Neglect from Charles and the bio mother.
I'm starting to notice a pattern of blaming everybody else for the situation that she's in. Like, it was the biological parents who mistreated their child, and she was the savior who fixed her. Like the child's father was the one who was abusing his daughter mentally, and yet she still decided to have 2 more children with him? And probably the best one, the child is mentally damaged because she's been kept from Karen for 2 months, which has probably been the quietest and most enjoyable 2 months of her life.
And now he tried to kill me. He said he was suicidal and then kidnapped our child.
He tried to claim her by claiming he was going to kill himself. Okay.
And then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nerswick.
So I tried to assert my rights to that child. by taking her, by attempting to take her, by harassing, by stalking, by blowing up his phone, like what's this asserting your rights to the child? Like, legitimately, we know you don't have rights to the child, but what does asserting your rights to the child entail? I just and glad to have you in for the live, Kidder, and Epiphanies. Good to have you in too. But there's just, this is just more conclusory statements. It means nothing.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you've made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So there's,
well, that's what I'm asking for the agreement, due to the fact I was not given any evidence. I wasn't.
It's called discovery, and I'm sure they'll teach you that at that super real law school that you super really study law at.
And
I wasn't given evidence. Yeah, you generally don't have discovery at arraignment. Now, it's possible the prosecution has already put together the discovery packet, and you just have to request it and go pick it up. But this is kind of the start. It's the start of the case. So evidence is presented at trial, or at, a preliminary hearing, or, whatever, as this is district court. I'm assuming it's a misdemeanor. Misdemeanors, you don't generally get preliminary hearings, at least not here in Utah. So I, can't say. But yeah, it's this due process that I'm receiving is real inconvenient. Why can't we go with my process instead? And yeah, but she's the legal expert here, not Miss Manarino, not the judge, not.
Like, I have proof that Chuck took this and tried to use it in a court to try to kidnap the biological children from me. And the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is
you're here. You weren't properly served. Were you arrested? Were you taken into custody? Were, like, saying I wasn't properly served? They got a warrant. You obviously have notice of the warrant. like, when you're there in court saying I wasn't properly served, this isn't a civil case. So the civil rules for service are different than criminal, because if you're arrested, that is your service. It's different.
Completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they use to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've
Thank you.
requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
I mean, do we even need to make the jokes that it's appropriate having her in court on April 20th? Like, I'm not saying she partakes in the wacky tobacco, but she's making the kinds of arguments that I would expect from people who partake in too much wacky tobacco. Once again, I don't know. I'm just... this isn't defamation from me. It's a joke. But, yeah. No appetizer. The service sucks. The appetizer came after the meal. And Imuji, good to see you. It's been a while.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green.
To talk to Charles about my daughter, Haley.
Well, she's not your daughter. She's not your daughter. And don't interrupt the judge. Don't talk over the judge. That's contempt. And Vera, thank you for the 5 gifted memberships. I always appreciate your support, and that's very kind of you.
I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal order.
True, but you do have to follow a court order or you will be held in contempt of court. Your bond will be revoked and you'll be attending all your future law classes at the Free Law Library in County Jail.
April 20th with Judge.
Yeah. Schlitzie has it covered on that one. If you don't follow the court orders, your bond will be revoked. And, you know, cue Deborah Davis. I know where there's free lodging.
Judge Green, ma'am. The court will now notice to the address that we have on file in this matter. Anything else,
Do it, Vince. Do it.
Ms. Manarino?
No, Your Honor, thank you.
I do
Anything
not
else, Ms.
consent
Kowalski?
to this, by the way. I do not consent to this interaction. I do not consent to these charges. I do not consent to any of it. It is
Good thing your consent isn't required.
erroneous, and I will be taking legal action against this court for not dropping this today.
I don't think the court values your entitlement as much as you do, Karen. All right, guys, that's the end of the video. She has another hearing in a couple of days, so I'll be bringing you that craziness soon. And a special thank you to Factor for sponsoring this video. Don't forget to check out the link in the description to try the service out for yourself. So if you liked the video, leave a like. If you disliked it, leave a dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.
All right. So obviously, I mean, I assume everyone here is already subscribed to Team Skeptic. So I will still say, you know, subscribe to Team Skeptic. And let's see. So that was, as I mentioned, roughly a year ago. And I'm curious. So that was this video. This is what crazy looks like, Karen in court. I'm just curious. On first glance, I don't see the subsequent court hearings, but either way. So moving on, I guess I need to switch the screen. There we are. So here we have Duneski versus Team Skeptic. And what we have is the civil complaint. We have the application to proceed without paying fees. So the informa pauperis application. And reassignment disqualification, which I'm cheap, so I haven't bought it. Don't know what that says, but either way, she has a history, as we'll see later on, of not even applying for the informa pauperis and just not paying fees, but she also has a history of not serving process, which, if you don't serve your opponent, you lose, because this whole due process thing she kept going on about, as I said, notice and an opportunity to be heard. Without the notice, there's no due process, so she's not going to win. So looking through her lawsuit, there are going to be basically 2 rules of civil procedure we need to keep in mind, and 2 Supreme Court cases we need to keep in mind. Now, my regular viewers who have followed me through the Delete Laws lawsuit, the TikTok Psychic lawsuit, the Girlies lawsuit, various others, will know what those rules are. So basically, I'm going to rely on the chat to tell me what's wrong with this. Tell me which rules of civil procedure are, well, number 1, which one wasn't followed, and number 2, which one will result in it being dismissed for the other one not being followed, and also tell me the 2 Supreme Court cases that process relies on. And I will pull it up as it, as we go on, but so, and Vince, that's true for diversity jurisdiction cases. So if it's federal question or constitutional, or, you don't have to, but for diversity jurisdiction, there has to be complete diversity of the parties, meaning all defendants and plaintiffs live in different states. So, all the defendants can live in one state, but that has to be a different state from all of the plaintiffs. But so you have to have complete diversity and at least $75,000 in damages. And Paul Berry has one of the Supreme Court cases that are going to be relevant. That is Bell Atlantic versus Twombly, or is it Twombly versus Bell Atlantic? I can't remember. It's just referred to as Twombly. And Imuji has the second of the rules, 12b6. So Grey Duck has the portmanteau combining the cases. So Twombly and Iqbal, spelled with a Q, not a CH, but you know, it's Arabic, so it's a difficult spelling. So that's not one of the rules that I was mentioning, but that is going to be a problem. So that could be a problem as far as you, because this is Lindsay and Duneski versus Team Skeptic and YouTube, but that like it could be, and that's the terms of service. So, well, Twombly doesn't have a lot of frivolous lawsuits to answer for. Twombly short-circuited a lot of frivolous lawsuits, so that's good. But so let's take a peek at the complaint, and as I mentioned, as bad as delete laws is, he Ms. Duneski makes delete laws look like an actual legal scholar. I mean, this is bad. This is really bad. So it is in the United States District Court for the Eastern District of Michigan, and it's Lindsay Ann Duneski, plaintiff, versus Team Skeptic and YouTube defendants. And it's assigned to Gershwin A. Drain and referred to Kimberly G. Altman. And it is claim of harm and trespass and demand for trial by jury due to violations of constitutional rights. Now, Team Skeptic and YouTube, not being governments, it's hard to believe that they violated her constitutional rights. But I don't see how they violated her constitutional rights. But so someone did mention that John Doe defendants are a problem. Now, she's suing Team Skeptic, and that's already a problem for her. So even before we get into the body of the complaint, she's suing Team Skeptic. Now, I don't actually know how Team has things set up, but unless she's suing Team Skeptic LLC or Team Skeptic Incorporated, or, you know, unless there's some sort of corporate entity suing Team Skeptic, you may as well sue Mickey Mouse, because Team Skeptic is a character. It's a fiction. So she, like, at best, it's an alias, but she doesn't say suing John Doe, also known as Team Skeptic. She's not saying she's suing Schlitzenheimer McGillicuddy, also known as Team Skeptic. She's suing Team Skeptic. So she's already going to lose unless Team Skeptic as an LLC or a corporation, or, unless Team Skeptic is an entity that she can sue. So, and then it's mentioned YouTube. Now, under YouTube's terms of service, those who have signed YouTube's terms of service agree, if they're going to sue them in the Northern District of California, or no, the Central District of California, I think, Central District. Specifically, I believe the Santa Clara or San Jose. So either way, they agreed to sue them in Silicon Valley because that's where YouTube was located. That's where YouTube's lawyers are, and you get to do in a contract a choice of law, choice of venue, and YouTube requires its users to sue them in California. Now, the reason I say it depends here is this arises out of a Zoom court hearing and a video by Team Skeptic. So, like, let's say my mom sued YouTube. My mom hasn't signed the YouTube terms of service because she doesn't use YouTube. So if someone put a defamatory video of my mom on YouTube, she could probably sue YouTube here at 123 Fake Street, not in California, because the terms of service don't apply to her. Now, I'm assuming that they do apply to Miss Duneski because she does have a YouTube channel. Not a big one, but she does have a YouTube presence. She obviously, has some YouTube presence because she leaves comments on Team Skeptic's videos. I'm expecting comments on this video. So I'm assuming she has signed the terms of service, in which case the Eastern District of Michigan is not the appropriate venue. So if she even bothers to serve YouTube, YouTube's going to say, yeah, no, this has to be in California. So I'm not saying that's going to happen because, once again, she has a history of not serving people. Service costs money, usually, if you use a process server at least. And suing people out of state, you're probably going to use a process server because, yeah. So chances are she's not going to bother. But either way, so this is a claim of harm and trespass and demand for trial by jury due to violations of constitutional rights. Well, it's not going to be a trespass because where's the trespass? Now, there are three in the common law. There are three main areas of trespass, and there's trespass to the person, and that would be, like hitting someone would be a trespass to the person, but that would be battery. So battery is a trespass to the person. There's trespass to property, going on someone's property without permission would be trespass to property. And then there's trespass to chattel. So like theft would be a trespass to chattel. But just bringing a cause for trespass, I don't see how Team has trespassed. But we'll keep going. So, introduction. This is a civil action seeking damages for defamation, intentional infliction of emotional harm, intimidation / tampering with a witness, trespass, harm, and violations of plaintiff's First, Fourth, and 14th Amendment rights under the U.S. Constitution. Well, couple problems there. Harm. Now, harm is an element in torts. It is an element in civil lawsuits. If you have not been harmed, unless it's a per se tort, defamation per se, you don't have to prove damages. But harm, you know, if she ever gets into law school, she won't. Like in her torts class, they will never teach about the tort of harm because it doesn't exist. Harm isn't a common law tort. It's an element of torts. Harm isn't like you can't sue for harm. So that's a problem for her. Now, intimidation, tampering with a witness, well, there's a criminal charge. And there isn't a private cause of action for it that I'm aware of. Like the state of Michigan would have to charge Team and YouTube with witness tampering and intimidation. Now, the obvious problem with that, of course, is it wasn't witness tampering anyway. Team wasn't trying to influence her to change her testimony. He wasn't trying to stop her from showing up. He's not a party to this. He's not associated with a party to this. He hasn't gone in, you know, he didn't say, hey, you better change your testimony or I'm going to feed your dog chocolate. There's making fun of someone isn't witness intimidation. It's not witness tampering. It's like that. It's threats. It's you better change your testimony or else. Or, you know, as prosecutors love to charge it, it's, you know, making jailhouse phone calls to your victim and saying, don't testify, because once I get out, there will be problems. It's just, not only is it not a civil private cause of action, even like nothing Team did violates the criminal law, and YouTube especially not. So, intentional infliction of emotional harm. Well, the tort is called intentional infliction of emotional distress. Now, it's not. Making fun of someone is not intentional infliction of emotional distress. You know, as I say, this tort is basically RICO light because it's never RICO and it's almost never IIED. It, like, number one, the conduct has to be extreme. Making fun of someone on the internet isn't extreme, the type of extreme conduct. And emotional harm, like it doesn't fit. It's wrong. And defamation, making fun of someone isn't defamation. Covering their embarrassing court hearing isn't defamation. like, we watched Team's entire video. There was no defamation. He didn't say this woman is a kidnapper. He didn't say this woman, you know, committed crimes of moral turpitude. This woman, you know, he said this woman's stupid and ridiculous. That's not defamation. So just doesn't work. So jurisdiction and venue. Oh, sorry. Before I move on, I forgot. So violations of the plaintiff's First, Fourth, and 14th Amendments under the U.S. Constitution. How? First Amendment, is it? I assume she's talking about freedom of speech, because religion wasn't brought up, the press wasn't brought up, you know, assembly wasn't brought up, petition wasn't brought up. So I'm assuming freedom of speech. Well, number one, Team Skeptic isn't the government, so him telling her to shut up isn't a violation of her freedom of speech. But how did he prevent her? How did he infringe on her freedom of speech? From the looks of it, she's trying to force the government to infringe on Team Skeptic's freedom of speech. But it just doesn't work that way. And Fourth Amendment, you know, the right to be free from unlawful searches and seizures without a warrant, be secure in your papers and effects and property and stuff. And how did he infringe on that? How did Google did they illegally search her car for drugs? Did they what? It just, where? How? Now, 14th Amendment, of course, you know, is the mechanism by which most of the Constitution is enforced upon the states. So, like, if you sue the state for violating your Fifth Amendment, or alternatively, you know, if you are a criminal and you are facing charges and you're trying to get your statement suppressed because of a violation of the Fifth Amendment, you also allege that it was violated through the 14th Amendment. So it's just kind of a mechanism, but but there is also the due process clause in the 14th Amendment, or is it, you know, the privileges or immunities clause in the Fourth Amendment? He violated her right to travel. And by that, I mean among the several states. But once again, how would he have done that? So, but let's see. So, jurisdiction and venue. This court has jurisdiction over this action pursuant to 28 U.S.C. Section 1331 because the claims arise under the Constitution and the laws of the United States. So she correctly cited federal question jurisdiction. So Section 1331, federal question jurisdiction. And the problem is, of course, they didn't actually violate her constitutional rights. And Therefore, it's only state common law claims that could actually survive. That they won't, but it's not going to work. So venue is proper in the Eastern District of Michigan under 28 U.S.C. Section 1391B because a substantial part of the events or omissions giving rise to the claims occurred in this district. And so what did Team Skeptic do in Michigan? The events giving rise. Now, Team Skeptic did this at 123 Fake Street, not in Michigan. So the events giving rise to this didn't occur in Michigan. So she'd actually have to be alleging the harm occurred in the state of Michigan. So think, Schofield versus Giard. The TikTok psychic, Ashley Giard, made the statements on TikTok in Texas. Professor Schofield is in Moscow, Idaho, and she felt the reputational harm in Idaho. She works at the University of Idaho. Her social network is in Idaho. Her job was put at risk in Idaho. The death threats she received in Idaho. So Professor Schofield alleged concrete harm felt in the state of Idaho, sufficient for Idaho to exercise its long-arm jurisdiction to drag Ashley Giard into the courts in Idaho. Here, the events or omissions didn't occur in Michigan. The court hearing occurred in Michigan, but Team Skeptic and YouTube didn't do anything in Michigan. So she'd have to allege the harm occurred in the state of Michigan. So parties. Plaintiff Lindsay Ann Duneski is a resident of the Eastern District of Michigan. Defendant, Team Skeptic, is an individual or entity operating a YouTube channel and conducting business via the internet. Defendant YouTube is a corporation organized under the laws of the state of Delaware with its principal place of business in California and conducts substantial business in the Eastern District of Michigan. And that's also true, Fletcher Boy. Ashley waived venue challenges, personal jurisdiction challenges, by not raising them in her responsive pleading. So, well, she at least hasn't alleged the correct jurisdiction properly, I don't think. So, and once again, it's Team Skeptic is an individual or entity. It's hard. And bad Scooter, good to see you. So once again, she's suing Team Skeptic. You may as well sue Mickey Mouse. I don't think she's properly alleged the party. It's if she doesn't know his name, you either have to put Schlitzenheimer McGillicuddy is an individual operating the YouTube channel Team Skeptic and conducting business via the internet. And frankly, conducting business via the internet, where is he domiciled? I realize she's trying to say this is federal question jurisdiction, but it's not. So, but, Schlitzenheimer McGillicuddy, also known as, or John Doe, also known as Team Skeptic, and then fill in the blank once you learn his real name, which is very difficult to do. How hard is it to find Schlitzenheimer McGillicuddy on the internet? So, factual allegations. Defendant Team Skeptic created and published an erroneous, misleading, and defamatory video on YouTube about plaintiff Lindsay Ann Dineski. This video was intended to torture, harass, and inflict undue emotional, mental, and reputational harm on plaintiff. Defendant Team Skeptic's actions were done with knowledge of the falsity of the statements or with reckless disregard for the truth, causing significant harm to plaintiff's reputation and emotional well-being. And it was torture. Say it ain't so. And, reckless disregard for the truth or knowledge of falsity. She's trying to say actual malice. I mean, for defamation per se, that's relevant, but, she's not exactly a public figure. So, and yeah, well, we might get that later. I don't actually know, but defendant YouTube allowed the publication of this defamatory video and enabled the deletion and censoring of comments that were true and served as a valid defense against the defamation. Censoring the comments on a private YouTube channel, on a I guess that's where the First Amendment claims come. She's mad that he deleted her comments. Deleting comments on your own YouTube channel is a First Amendment violation. Fuck me sideways, that's ridiculous. I mean, it's as if I were to take Victor's, late arrival and delete this comment. I'm not going to, Victor, but if I were to delete this comment, that would be me moderating my chat. It's not a First Amendment violation. It's yeah. Well, I mean, the sad truth is Janet might be a step up from this woman. Not much, but the ridiculous. So YouTube, at the request of Team Skeptic, censored these comments, making them complicit in the defamation and contributing to the harm suffered by plaintiff. Defendant's actions included intentional infliction of emotional harm by making false and derogatory statements intended to cause severe emotional distress to plaintiff. Defendants engaged in intimidation and tampering with a witness by using their platform to threaten, harass, or coerce plaintiff in relation to her involvement in legal proceedings. Defendants' actions have violated plaintiff's First Amendment rights by retaliating against her for exercising her right to free speech. How have they retaliated? And witness tampering, like them deleting your comments on Team Skeptic's video, that's not evidence for your court case. That's not evidence for your criminal charges. It's not evidence tampering. It's definitely not witness tampering because he hasn't stopped you. like, if anything, it's in aid of your Fifth Amendment right to shut the fuck up. It's not evidence tampering in this lawsuit because he didn't delete them in anticipation of litigation. If he deleted any comments, and it's possible the comments were just withheld because, if the YouTube AI picks up that you've violated the terms of service, it automatically withholds those comments, doesn't publish them. But like, if Team deleted comments that he determined weren't following the rules, were harassing or whatever, I mean, for hell's sake, he can turn comments off on videos. And that's not witness tampering. It's not a First Amendment violation. I mean, so many music videos on YouTube just have comments disabled. Is that a violation of my First Amendment right to comment on Justin Bieber videos, how much he sucks? No, it's not. And that's it. Unless it violated terms of service, Team lets people talk. I mean, hell, in the short where he said this crazy lady is suing me, he engaged with her rambling comments. Others engaged with her comments. It's like, the more deranged a comment, as long as it's not violating terms of service, it sparks engagement, and that's good for the algorithm. It's good for the algorithm. And so he pins them so that he gets the engagement. It's how your channel grows. So, defendant's actions have violated plaintiff's First Amendment rights by retaliating against her for exercising her right to free speech, because they're required to give her a platform to speak. And of course, she has posted videos on YouTube. So, like, if you need an opportunity to respond to refute Team Skeptic's allegations, which once again, they're not allegations, they're just making fun of her. But if she needs to say, I do not eat crayons, I sniff markers instead, that's my colorful food of choice. Once again, that's not defamation, Lindsay. That's a hypothetical. That's hyperbole. That's a joke. It's not defamation. But if she needed to say that, Team Skeptic doesn't have to provide her with the platform to say that in his comments. She can make a video and post it on hers. She can even tag Team Skeptic in the description and say, response to Team Skeptic, no, I do not eat crayons. By the way, Crayola is the most delicious. So, yeah. And, well, the incorporation by reference is just the part I usually yada yada over, saying she's re-alleging all these factual claims for the cause of action. So it's not, at least not what's on screen, it's not incorporating the YouTube video by reference. So defendants have violated plaintiff's Fourth Amendment rights by intruding upon her privacy through unlawful means. No. Like, no. And I mean, like, the right to privacy is not in the Fourth Amendment. That's the right against unlawful searches and seizures and stuff. But like Roe versus Wade was determined on the right to privacy, I believe. It's not explicitly in the Constitution. It's been a long time since I was in law school, but basically the right to privacy is kind of imputed to the Constitution, and so Griswold versus Connecticut is where they found the right to privacy, and that was the contraceptive case, basically saying, yeah, we have the right to use contraceptives. And the court found, yeah, you have the right to use contraceptives because of the right to privacy, the right to marital privacy, it says. And it applied the First, Third, Fourth, Fifth, Ninth, and 14th Amendments. And so the court rejected the due process clause of the 5th and 14th Amendments as a source of marital privacy, because at the time the court still formally rejected the doctrine of substantive due process due to its association with Lochner. Instead, they used substantive due process and said marital privacy was implied by the specific provisions of the Bill of Rights, such as those in the First, Third, Fourth, and Fifth Amendments. And, you know, like Third Amendment, you can't be forced to quarter troops in your house, implies a right to privacy. So, yeah. It just, they haven't violated her right to privacy. It was a public court hearing. He made fun of her public court hearing. He made fun of her public court documents. Those aren't private. He wasn't in the bedroom. It's not there. And Brandon, thank you for the super chat, and screw Flanders. Screw that stupid, sexy Flanders. And I really appreciate it. And yeah, I read through the comments, and they're deliciously awful. Like, she wants a debate and wants to go on his channel to put out her evidence. She's got a channel. She can put out the evidence on her own. He doesn't have to provide her with a platform. Not providing her with a platform for speech isn't a First Amendment violation. And yeah, I'm gonna appeal it all the way to the Supreme Court. No, because you're not even going to serve him. Like, the Supreme Court would never take this case. But in the comments, she also said basically that delete laws was on the right track. That that tells you what you need to know. So and it's she probably didn't think of that, is the thing. Like, I don't think she's very smart, so I don't think she even thought about her own platform. Of course, it's also possible she just wants the amplification of Team Skeptic's platform. You know, going on a channel with 100 and what is it? Scroll to the top. 157,000 subscribers. You get, you know, you have a lot more amplification than going on her own channel, which I'm not going to pull it up, but yeah, a lot more amplification. So that's probably why. So defendant's actions have also violated plaintiff's 14th Amendment rights by denying her equal protection under the law. But once again, they're not the government. They, like, equal protection, does that mean any old Tom, Dick, or Harry can go on demand access to Team Skeptic's channel to put out videos if they want? Like, is that what she thinks equal protection of the law is? I mean, like, and as far as YouTube is concerned, how have they denied her, intruded upon her, denied her equal protection of the law? Well, number one, there's not a law saying that YouTube has to let everyone have a channel or go on Team Skeptic's channel, but she has her own channel. So the YouTube has provided her the same access to YouTube as it's provided to Team Skeptic. So is it just an equal protection violation that YouTube hasn't given her 157,000 subs? Not how that works. So, defendants committed trespass by intruding upon plaintiff's physical or virtual property without consent, causing harm. Physical or virtual property. Two problems with that. The court video, the court feed, not your property, physical or virtual. The public court filings are public, not your property, physical or virtual. Like, what did he take? What did he deprive you of? What did he illegally gain access to? Nothing. It's, well, and that's it. All of this is conclusory. That there's, other than Team Skeptic made a video about her, this has all been conclusory. And it frankly, it's all legal conclusions, not even factual conclusions. It's legal conclusions. It's preposterous. So, claims for relief. Count 1, defamation. Plaintiff realleges and incorporates by reference each and every allegation set forth in the preceding paragraphs. So that's basically her saying paragraphs 1 through 17 apply to the defamation allegation. So, defendants made false and defamatory statements about plaintiff. Defendants acted with actual malice or with reckless disregard for the truth. Plaintiff has suffered harm to her reputation and emotional distress as a direct result of these statements. Should we analyze why this is so bad now, or should we get through the end of the document first, and then we'll discuss Twickball and Rule 8 and Rule 12b6, and probably 12b1, 2, 4, all the 12b's. I think we'll wait till the end, but it's conclusory statements. That's the problem. There is no factual allegation here. So this is just bad. This is just really, really, really bad. And that's a reasonable conclusion to make based on her public actions. And Fletcher Boy, thank you very much for the super chat. And getting butt hurt isn't illegal. No, it's not. It's you not liking what someone says about you. Like, it sucks, but it's not illegal. It's not a tort. There's no cause of action for hurt feelings. It has to be actual false statements causing harm published, but all this is she's recited the elements of the cause of action. No factual allegations. It's just, these are the elements of the cause of action, therefore I win. But you don't. So, count 2, intentional infliction of emotional harm. Plaintiff realleges blah, blah, blah. Defendant's conduct was extreme and outrageous. Defendants intended to cause or acted with reckless disregard for the likelihood of causing severe emotional distress to plaintiff. Plaintiff has suffered severe emotional distress as a direct result of defendant's conduct. Once again, that's just reciting the elements of the cause of action. Count 3, intimidation / tampering with a witness. Plaintiff realleges and incorporates blah, blah, blah. Defendants engaged in conduct intended to threaten, harass, or coerce plaintiff in relation to her involvement in legal proceedings. Plaintiff has suffered harm as a direct result of defendant's conduct. Threadbare, just bare recitations of the cause of action. So, violation of First Amendment rights. Plaintiff realleges and incorporates. Defendants retaliated against plaintiff for exercising her right to free speech. Plaintiff has suffered harm as a direct result of defendant's conduct. Count 5, violation of Fourth Amendment rights. Plaintiff realleges, blah, blah, blah. Defendants intruded upon plaintiff's privacy through unlawful means. Plaintiff has suffered harm as a direct result of defendant's conduct. Count 6, violation of 14th Amendment rights. Plaintiff realleges, blah, blah, blah. Defendants denied plaintiff equal protection under the law. Plaintiff has suffered harm as a direct result of defendant's conduct. Count 7, trespass. Plaintiff realleges, blah, blah, blah. Defendants intruded upon plaintiff's physical or virtual property without consent. Plaintiff has suffered harm as a direct result of defendant's conduct. Demand for trial by jury. Plaintiff demands a trial by jury on all issues so triable. Relief not relief demanded, relief requested. It's relief required under the law. Relief required. And sweet dreams, thanks for joining us. But yeah, it's rules for thee, not for me. That is the First Amendment of the sovereign citizen Constitution. Rules for thee, not for me. And Amendment 2 is, I make up those rules. So, wherefore, plaintiff Lindsay Ann Duneski respectfully requests that this court enter judgment in her favor and against defendants, Team Skeptic and YouTube, and award the following relief. Compensatory damages in an amount to be determined at trial. Punitive damages in an amount to be determined at trial. Injunctive relief preventing defendants from engaging in further unlawful conduct. So basically, she wants to restrict Team Skeptic's First Amendment rights. She wants prior restraint against Team Skeptic. Tell him he's not allowed to say mean things about me online. That's prior restraint. That's unconstitutional. That would be the government violating Team Skeptic's First Amendment rights. Team Skeptic allegedly deleting comments on his video, that's a violation of the First Amendment. But me asking the government to use prior restraint and keep Team Skeptic from talking about me, that's fine. It doesn't work that way. Costs and attorney's fees as allowed by law. Well, you studying to be a lawyer don't get attorney's fees. You're pro se. So such other relief, other and further relief as justice and the law requires. I, lowercase I, declare under penalty of perjury under the laws of the state of Michigan that the foregoing is true and correct. Lindsay Ann Duneski, living woman. Sui juris in propria persona petitioner, signed Lindsay Ann Duneski. Got to get a little of that quantum grammar in there. So, why is this so bad? Well, number one, it's frivolous. We know that. We know that. But let's see why. So we need the federal rules of civil procedure. And I mentioned two rules. You guys came up with one of them, but the first one we need is Rule 8, the general rules of pleading. And we are specifically looking at Rule 8A, claim for relief. A pleading that states a claim for relief must contain 1, a short and plain statement of the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. So she did that. Not real well, but she did that. She's claiming federal question jurisdiction. It's frankly, she should have also claimed supplemental jurisdiction, the bootstrapping jurisdiction, because that's the jurisdiction she's relying to get the state law claims in alongside the federal question jurisdiction. So a good practice would have been mentioning that. But 2, a short and plain statement of the claim showing that the pleader is entitled to relief. So that's the body of the lawsuit. It's, they did this. This is the cause of action. And yada, yada, yada. So, that Alpha, when you get to it, I assume you're talking about the Burger King case. But yeah, forum selection is a big thing. And we also are going to need to talk a little bit about choice of law. But we'll get to that. So, and then 3, you need a demand for the relief sought, which may include relief in the alternative or different types of relief. So that was the prayer for relief, the relief demanded, or in this case, the relief required by law. And yeah, so the next rule we need to look at is Rule 12. And that's defenses, objections, when and how presented, motions for judgment on the pleadings, yada, yada, yada. And so I don't know the big twist in this case, but either way. So we're specifically looking at Rule 12b, how to present defenses. So every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party may assert the following defenses by motion: lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, and our favorite, Rule 12b-6, failure to state a claim upon which relief can be granted, and then 7, failure to join a party under Rule 19. So what's going to happen is, if Team is ever served, or YouTube, they'll file a motion to dismiss for failure to state a claim upon which relief can be granted. If they're not served, there will be insufficient service of process. Of course, it'll just be auto-yeeted if proof of service never arrives. See, for example, Delete Law's Las Vegas case, where he never served the state of Nevada, which has sovereign immunity anyway, so it doesn't matter. But recently the court announced, so the state of Nevada is automatically dismissed because they were never served, so bye-bye, and the rest of the defendants are soon going to follow. So Vince, I assume that's the reassignment disqualification that you're talking about. Email it to me. And yeah. So basically, in analyzing Rule 8, and helps if I hit the right key. I don't want Cy Twombly. Oop, no, I won't. So I know Wikipedia, not a great source, but I know this is accurate. It's just a good summary. But we need to look at the Supreme Court cases, because in the past, the pleading standards for Rule 8, the short and plain statement giving rise to relief, is basically okay. So Vince, I'm assuming it's one of these cases that, okay, Duneski versus X. So that's one we'll look at. But yeah, so in the past, the pleading standards under Rule 8 to survive a 12b-6 motion were pretty easy to meet. Christo, good to see you. But they have become harder. It's still, so long as you allege actual facts in your complaint, you're going to survive the motion to dismiss. But the 2007 Supreme Court case, Bell Atlantic versus Twombly, raised the standard. And then the 2009 case, Ashcroft versus Iqbal, clarified what that standard actually is. And so they're kind of companion cases. That's why they're referred to as Twickball, and they're the pleading standard. So basically, this quote in Iqbal is the big part, like it's the meat of the matter. So it's kind of long, but I'll read it. So, two working principles underlie our decision in Twombly. First, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. I should have said, because I assume I have new viewers each different case I cover. So I'm not imputing knowledge to existing viewers to new viewers. So in a motion to dismiss, in a 12B6 motion, the factual allegations made by the plaintiff are assumed to be true. They are viewed in the light most favorable to the plaintiff. But only for the motion to dismiss. So later on, like let's say for a summary judgment, it's viewed on the undisputed facts. At trial, unless it's a stipulation, the jury doesn't have to assume any facts. They get to assign weight to the testimony. But you assume facts to be true. But here, it's legal conclusions are not assumed to be true. So you saying I was defamed is a legal conclusion. That's not afforded the assumption of truth. The saying this person said this about me, it's false because of this, therefore I was defamed. Those facts, this person said this about me, this is the harm I suffered, it was published here. Those facts are assumed to be true in the complaint for the purposes of the motion to dismiss. Therefore, you could reasonably determine that if true, and they're assumed to be true, defamation exists. But just saying I was defamed is a legal conclusion. It doesn't get the benefit of being accepted as true. So, second, only a complaint that states a plausible claim for relief survives a motion to dismiss. Determining whether a complaint states a plausible claim for relief will, as the Court of Appeals observed, be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. In keeping with these principles, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because they are no more than conclusions, are not entitled to the assumption of truth. While legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. When there are well-pleaded factual allegations, a court should assume their veracity and then determine whether they plausibly give rise to an entitlement to relief. Our decision in Twombly illustrates this two-pronged approach. Now, plausible claims for relief. So, looking at Ashley Giard in her counterclaims against Professor Schofield, the court can't plausibly believe her tarot card readings as providing truth. Let's see. Clicking on Twombly, I'm not going to search for it any further. But basically, Twombly says threadbare recitals of the elements of a cause of action do not suffice. You have to have factual. You have to plead facts. So, in order for this person to even survive a motion to dismiss, to survive a Rule 12b6 motion by Team Skeptic and YouTube, she can't just say, for defamation, defendants made false and defamatory statements, defendants acted with actual malice and reckless disregard for the truth, plaintiff has suffered harm. That's just threadbare recitals of the elements of the cause of action. This is exactly what Twombly says isn't good enough. So, like, you have to fill in the blanks. You have to say, Team Skeptic made this video about me. It is titled this. It said this. He said this. This is false because I have suffered this damage. He published it here. You like in law school, they teach you for legal writing, for briefing a case, for taking notes, the IRAC method. And there are a few other methods. My law school taught IRAC: issue, rule, application, conclusion. Issue: Team Skeptic defamed me. Rule: defamation in the state of Michigan occurs when a defendant makes false or defamatory statements about the plaintiff, publishes them, and, blah, 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 and the defendant or the plaintiff suffers harm, and it's defamation per se if they acted with actual malice, or if the defendant's a public figure under the New York Times versus Sullivan, or Sullivan versus New York Times, can't remember. Same, actual malice applies. So that's the rule. Analysis: Team Skeptic made a video. It contained these false allegations. Team Skeptic knew they were false, or should have known they were false. I suffered these damages. Conclusion: defamation. She did within IRAC. She only did R. No issue, no application, no. Well, I guess conclusion, R and C, but they're combined into the same thing. So she did that with each and every one of the causes of action. But it's even worse than that, because even the factual allegations are just conclusory. It's the court doesn't have to take conclusory statements as fact. Just a collection of conclusory statements with the elements of a cause of action. It's not a complaint. There is no court in the country where this complaint would survive a motion to dismiss. So yeah, maybe whoever is teaching her the law needs to give her a refund, because they have not done a good job teaching her about the law. She said in the video she's studying to be a lawyer. She didn't say she's in law school, just studying to be a lawyer. But she's not doing a good job at it. Let's see. I think there were other things I wanted to talk about, but I am going to talk about this fun stuff. We're going to take a peek at some of her other lawsuits, because as I mentioned, she is just a constant frivolous litigator. And we have Duneski versus Duneski, initiating a motion and declaration to void all judgments, orders, debts, and award reasonable damages and expenses in connection to the child custody case. So basically, she's trying to get the federal court to overturn the child custody arrangement, and filing ex parte motions, and yeah, it doesn't look like anyone's ever been served. It's yeah. So there's that one, and that's from 2021. From 2023, we have another Duneski versus Duneski, initiating motion and declaration to void all judgments, and yada, yada, yada. Let's take a peek at the order dismissing it. So this matter first came before the court on September 28th, 2021, as part of its miscellaneous docket. Plaintiff makes several requests, among others, to 1. Void all judgments, reliefs, debts, orders, etc. made by South Carolina's Greenville County Family Court related to the aforementioned case numbers. 2. Facilitate the safe and immediate return of the minor children to plaintiff. 3. Restrain defendant Kenneth Duneski Jr. and all of his accomplices from contact with their children. And 4. Pursue criminal charges against the involved parties. That's a good point. That's a good point. And yeah, it's almost like federalism doesn't exist to sovereign citizens. But for the reasons explained below and discussed at length in the court's January 23rd, 2024 order to show cause, plaintiff's complaint is dismissed with prejudice. The complaints of litigants without lawyers are construed liberally. Nonetheless, they must comply with Federal Rule of Civil Procedure 8A, which we already looked at, which requires the complaint to contain a short and plain statement of the claim showing that the pleader is entitled to relief. Rule 8 does not require detailed factual allegations, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. And that's Iqbal and Twombly. A complaint is considered frivolous and subject to dismissal if it lacks an arguable basis in either law or fact. And that's Knightsky versus Williams from the Supreme Court. We've seen that cited before too on this channel. The South Carolina court, which plaintiff asks this court to enjoin, has already found merit in the claims of defendant Kenneth Janeski, rejected plaintiff's counterclaims and allegations of impropriety, and entered judgment against her. Plaintiff is now barred from reasserting the same claims she presented or should have presented to that court. Additionally, insofar as plaintiff seeks to impose liability on defendant here, her theories are necessarily premised on the invalidity of the state court's decisions and are, therefore, barred by the doctrine of collateral estoppel. We've talked about collateral estoppel before. What was it? What was it? Can't remember what case we talked about collateral estoppel, but yeah. So accordingly, on January 23rd, 2024, the court issued an order to show cause. The order explained the deficiencies in plaintiff's complaint. It also warned plaintiff that if she did not file a response within 15 days or filed any non-responsive documents, this matter would be dismissed on the merits. The 15-day period has elapsed without further action by plaintiff. Plaintiff's claims remain patently frivolous and should not be permitted to consume the resources of the court or the other parties. Conclusion, plaintiff Lindsay Janeski's complaint is dismissed with prejudice pursuant to 28 U.S.C. section 1915E2B. All pending motions are denied as moot. And that's signed by the judge, and you'll notice this was in the United States District Court for the Eastern District of Michigan, trying to get them. So not only was she trying to get a federal court to overturn a state court's rulings, they were trying to get the federal court in Michigan to overturn the South Carolina state court. That's wild. That's wild. That not only is that trying to get a different court to violate the sovereign, a sovereign state, it's trying to get a different sovereign state to violate the sovereigns. Like, it's wild, absolutely wild. And the thing is, Linux guy, I do like, I think we did discuss it about blue bacon and that, but I think it was a different case, like not a delete laws case, where I discussed collateral estoppel, because well, it might have been, but there were threats of other lawsuits from someone, like, once I get done with this, it was about Ashley Giard, because Ashley made the video and she was specifically threatening Markey and Atozi, but also everyone else talking about it, so me. And she was like, once this case is over, I'm suing all of you as well. And I said, the problem with that is, once you've lost to Professor Schofield, that issue's been decided. And because of collateral estoppel, all we'd have to do is say, hey, no, this has already been ruled, so we win. So that's the one I was trying to remember. And CJ5, good morning. I hope you're having a good morning in the upside down. So that's the Duneski versus Duneski. The Duneski versus X that apparently the YouTube and Team Skeptic lawsuit is being merged with. Completely different format, and she's bringing this action against X, formerly known as Twitter, seeking redress for violations of her rights under color of law. Lindsay Ann has evidence that X conspired and colluded with the FBI in each allegation and demands a trial by jury to address the following claims of harm and trespass. Parties: Lindsay Ann Duneski is a resident of the Eastern District of Michigan. X is a corporation organized and existing under the laws of the state of Delaware, with its principal place of business in Menlo Park, California. Jurisdiction and venue: this court has jurisdiction over this action pursuant to 28 U.S.C. Section 1331, as this case arises under the Constitution and laws of the state of the United States. Venue is proper because the events giving rise to the claims occurred within the district. Factual allegations: X, in collusion with the FBI, engaged in actions constituting malicious prosecution against Lindsay Ann. X conspired with the FBI, discriminating against Lindsay Ann based on her religious and philosophical views. X, in conspiracy with the FBI, violated Lindsay Ann's freedom of speech by unlawfully censoring her communications and content on the platform. To get censored on Twitter now, on Shitter, you really have to be spouting outrageous bullshit. So if Twitter is censoring her, she's got problems. She's got problems. X, in collusion with the FBI, denied Lindsay Ann due process by participating in actions that lacked fair legal procedures. X, in conspiracy with the FBI, failed to provide equal treatment under the law, targeting Lindsay Ann unfairly and disproportionately. X, in collusion with the FBI, engaged in unlawful surveillance of Lindsay Ann's online activities, infringing upon her privacy rights. If you don't want Twitter surveilling your online activities, don't post on Twitter. And yeah, social media spies on you too much, but by logging in, by using the sites, you gave them permission. It's in the terms of service. It's not unlawful surveillance. It sucks, but yeah. X, in conspiracy with the FBI, tampered with Lindsay Ann as a witness by interfering with her ability to communicate and present evidence to the public through censorship. X's censorship of Lindsay Ann's communications and content prevented her from effectively sharing information and communicating her side of the story, thereby tampering with her ability to act as a witness in her own defense. This interference constitutes tampering with a witness by inhibiting Lindsay Ann's ability to present evidence and communicate effectively with the public. um, uh, um, apparently, according to her, you can tamper with a witness in the court of public opinion. Does she think the court of public opinion is an actual lawful court where witnesses can be tampered with? Uh, 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 um, uh, um, uh, um, uh, seriously? You see why this skipped to the front of the line, and I did a rare Saturday stream to go over this. It's wild. It's wild. X actions in collusion with the FBI amount to treason, torturing Lindsay Ann through persistent harassment and intimidation. It's treason. Treason. Twitter is and with enemies of the United States taking action against the United States by torturing Lindsay Ann. Treason. 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 Treason isn't a private cause of action. It's not a private cause of action. Censoring her on Shitter isn't treason. I know you guys know that, but treason. And I just realized I should have done that, made it bigger. Why didn't you guys tell me? But treason. And X, in conspiracy with the FBI, cyberbullied Lindsay Ann, subjecting her to online harassment and abusive conduct. Claim and assertion of right to relief, to required relief. Count 1, violation of civil rights under color of law, 42 U.S.C. Section 1983. X, acting in collusion with the FBI, deprived Lindsay Ann of her rights, privileges, and immunities secured by the Constitution and laws of the United States, including, but not limited to, nothing. Unless including but not limited to the following counts, but it's including but not limited to what? Like you have a full colon there, but including but not limited to what? Nothing. And it. So count 2, trespass. X, in conspiracy with the FBI, trespassed on Lindsay Ann's personal rights by unlawfully surveilling her and interfering with her digital presence without consent. So they unlawfully surveilled her by allowing her to post on Shitter. Well, it might have already happened. Or it might be it hasn't happened, but she's no longer allowed informa pauperis. So she has to pay, but she's not vexatious yet. So yeah, it's like if you don't want people to read things you post, don't post them online. That easy. But so count 3, harassment and intimidation. X, in collusion with the FBI, engaged in a pattern of harassment and intimidation, causing Lindsay Ann severe emotional distress and harm. Count 6, violation of U.S. Code Title 18, Sections 241 and 242. Once again, Title 18, criminal law. There is no private mechanism to enforce Sections 241 and 242. Yeah, and that helps to get her labeled vexatious. At least in that district. So X, in collusion with the FBI, violated Lindsay Ann's rights under Title 18, U.S. Code Sections 241 and 242, which prohibit conspiracies to deprive individuals of their civil rights under color of law, and the willful deprivation of rights under color of law, respectively. Count 7, discovery request. Lindsay Ann requests all account information and communications between all governmental agencies, agents, or officers pertaining to her or her account maintained by X. Count 8, restraining order rights. Lindsay Ann Duneski asserts her rights to seek federal restraining order prohibiting X or any governmental agencies, officers, or agents from censoring her on any social media platforms. Such censorship infringes upon her freedom of speech and violates her constitutional rights, preventing her from having her side of the story heard by the press and court of public opinion. So apparently she does think the court of public opinion is a court. Like, court of public opinion. And so she wants the federal government to infringe on Shitter's freedom of speech by forcing them to publish her ramblings. It's I mean, Mark Zuckerberg and Elon Musk are both poor facsimiles of human androids, but they're different companies. Demand for relief. She wants compensatory, punitive, an injunction, attorney's fees, other relief, immediate award of interim funds for reasonable living. Seriously, she wants interim funds, immediate award of interim funds for reasonable living expenses, costs, and provisions to sustain Lindsay Ann Duneski through the proceedings. Damn you, Vince. Like, I literally have tears in my eyes from this. This is almost as unhinged as that guy up in Ogden. So that the Rayland Brunson that was suing to overturn the election multiple times in Utah State Court. For those of you who haven't seen it, go back and watch those. They're wild. They're hilarious. They're just I need to compose myself first, Hank. I need to compose myself first because she broke me. And Schlitzy, you weren't here at the beginning, CJ5. I'm Schlitzenheimer McGillicuddy, and so is Team Skeptic. He goes by Schlitzy, I go by Jaime. It's kind of like the situation in the greatest movie ever made. I'm Brian, and so is my wife. The malicious prosecution prevents Lindsay Ann Duneski from being able to work in the public, and filing court documents to stop the malicious prosecution takes up almost all of her time. What malicious prosecution? You're the one bringing malicious prosecution against Twitter. Like, has Twitter sued you? Where's the malicious prosecution? The Twitter deleting your violations of terms of service is malicious prosecution? No. So, and she seeks the rights to seek a federal restraining order. I declare, under penalty of perjury, under the laws of the state of Michigan, that the foregoing is true and correct. Lindsay Ann Duneski, living woman, sui juris, in propria persona, petitioner, and yeah, that's yeah. The other way around, Grey Duck. The law clerk received this and ran into the judge's chambers and said, "You've got to read this. It's the funniest shit ever." That's how it actually went down, because the clerk read it first. And then they had a laugh together, and everyone clapped, and they lived happily ever after. Wow. Oh, and I should point out, application to proceed without prepaying fees. But there's more. That was filed May 21st. Also filed on May 21st is Duneski versus Facebook. And this was reassigned or disqualified. I'm presuming that means it was merged into the shitter case, just like Team Skeptic was. So basically, Facebook is colluding with the FBI. Facebook discriminated against her religious and philosophical views. Facebook violated her freedom of speech due to censoring her communications on their platform. Facebook colluded with the FBI to deny her due process by participating in actions that lacked fair legal process. They failed to provide equal protection under the law by targeting her unfairly and disproportionately. They violated her privacy rights. In conspiracy with the FBI, Facebook tampered with her as a witness by interfering with her ability to communicate and present evidence to the public through censorship. Facebook's censorship of Lindsay Ann's communications and content prevented her from effectively sharing and informing and communicating her side of the story, thereby tampering with her ability to act as a witness in her own defense. This interference constitutes tampering with a witness by inhibiting her, blah, blah, blah. It's treason, it's cyberbullying, 42 USC, 1983, trespass, harassment, 241, 242, discovery request, restraining order rights, demands for relief. She wants living expenses. So she wants to double dip. She wants living expenses from Facebook and Shitter. Wow. So, yeah. This was, this was basically a copy paste of the Shitter lawsuit, just substituting Facebook for Shitter. Same claims, same everything. So, if it's the same claims and same everything, you have to bring them in the same case. And that's why it was reassigned disqualified. Yeah, pretty much. Oop. Go forward. So, yeah. Let's see what's next. Duneski, Eastern District of Michigan, filed April. Okay, we don't even have the complaint, but we're missing docket number 1, so that's kind of the problem with court listener as opposed to pacer. But the opinion granting the application to proceed in forma pauperis and dismissing it as frivolous. So she brought this as a notice of claim of harm and trespass and assertion of right to emergency ex parte writ of habeas corpus with writ of attachment. So the court found it frivolous. Duneski is challenging state court proceedings which resulted in the custody of her children being awarded to Charles Nurswick. The proceedings were held before Judge Regina Triplett in the 3rd Judicial Circuit Court of Michigan. Duneski challenges Nurswick's standing to seek custody and argues that his paternity should have been established before the matter proceeded. So you file an appeal. You don't sue in federal court. She also asserts that Nurswick came into the child custody proceedings in bad faith, with unclean hands due to violating numerous laws, and that he committed perjury and fraud on the court. Duneski claims that Judge Triplett ignored her arguments and violated her due process and equal protection rights. In the filing, Duneski also claims an unlawful seizure and or kidnapping of herself and her children by the FBI. She further claims that Judge Triplett ordered the children injected with an experimental medical treatment against Duneski's will and in violation of her sincere religious beliefs. So vaccinated them. And not even necessarily against COVID, I'm assuming any vaccination. Duneski asserts that the state court judgment in the custody proceedings is void. She asks this court to order a full criminal investigation and the immediate return of her children to her. Well, number one, that's a federalism issue, but also a court can't order a full criminal investigation because, the court's the judiciary. The criminal investigation happens in the executive branch because the police and the prosecutors fall under the executive branch. Courts, judicial branch. Separation of powers, kind of one of the good things in our Constitution and state constitutions. And yeah. So the court lacks jurisdiction over this matter, which is essentially a child custody dispute. Domestic relations matters fall within the exclusive jurisdiction of state courts. So you can't even bring diversity of jurisdiction claims on custody matters because states exercise exclusive jurisdiction. So the domestic relations exception precludes federal courts from exercising jurisdiction over cases whose substance is generally domestic relations. And that's Chambers versus Michigan from the Sixth Circuit, citing Barber versus Barber from the U.S. Supreme Court. This exception, as articulated by the Supreme Court since Barber, all the way back in 1858, and I need to replace my battery in my headphones because it's cutting out and driving me nuts, and I use a lot of batteries in my headphones streaming trials. You know, those 8-hour trials really eat through batteries. But so all the way since 1858, when the Supreme Court decided Barber versus Barber, the whole subject of domestic relations of husband and wife, parent and child, belongs to the laws of the state and not to the laws of the United States. Now, of course, when it comes to, say, the interstate compact and, you know, the full faith and credit, and that might go to federal court. I don't actually know because I don't do family law. But the Supreme Court has consistently held that federal courts lack the power to issue divorce, alimony, and child custody decrees. Even when brought under the guise of a federal question action, a suit whose subject is domestic relations generally will not be entertained in federal court. That's Firestone versus Cleveland Trust Company, I assume, Sixth Circuit. See also Lehman versus Lycoming County Child Services Agency, Supreme Court, which denied federal habeas corpus jurisdiction in a challenge to state court involuntary termination of parental rights. Additionally, under what is referred to as the Rooker-Feldman Doctrine, federal courts lack jurisdiction to review matters litigated and decided in state courts as only... One second. As only the United States Supreme Court has jurisdiction to correct state court judgments. Because state laws are decided by state courts. State court judgments are appealed up to the state Supreme Court, and only the federal Supreme Court can say, yeah, no, that was unconstitutional. Bad state Supreme Court, do better. The Rooker-Feldman Doctrine prevents consideration of Dineski's claims as to any alleged violations of her rights that occurred concerning the award of custody to Nurswick in the state court proceedings, because such claims amount to nothing more than an impermissible backdoor or collateral challenge to an adverse order entered in the state court. See Stevens versus Hayes, Sixth Circuit, which affirmed the dismissal of parents' tort claims that collaterally attacked state court judgments which terminated their parental rights based on both the Rooker-Feldman Doctrine's principles of comity and deference to state expertise in the field of domestic relations. So comity is the principle where, you know, courts respect other courts' decisions. And then Partridge versus Ohio, also from the Sixth Circuit. Partridge's federal case is essentially an impermissible appeal of the state court's judgment as it raises specific grievances regarding decisions of Ohio's domestic relations courts. So therefore, it's dismissed because the court can't rule. So Yeah, that was a fun one. And then back in 2020, we have Duneski versus Greenville County Sheriffs. And this one, she applied in form of papyrus. Let's see. All right, yeah. So this one, no service, so it was dismissed, presumably. Maybe. Yeah, either way, whole lot of litigation, but I guess she did finally serve them, but either way. Duneski versus Priest. And okay, this is the one we want to read. So this was okay, what she sued Team on May 23rd. This order was made May 31st. So unless there's one that was made before the 31st, it might not apply to Team, but it's possible. So this is, I don't know who Price is or Price or however, but this is the order we want to read. This is going to be the final document we read today because it's been 3 hours. And so Duneski versus Stephanie Price, Southern Division, or so Eastern District of Michigan, Southern Division. Okay, so this is the opinion and order granting her motion, her application for in form of papyrus. So you don't have to pay anything, but if you do in form of papyrus, there's a short circuit mechanism because if you basically, if you're not going to even pay the filing fees, we're not going to entertain frivolous cases. So basically, that's where we are. So, so it's dismissed and enjoining plaintiff from filing further actions without leave of court by the presiding judge. So, yeah, that's a fair assumption. So, plaintiff Lindsay Ann Duneski, proceeding pro se, has filed a complaint against defendant Stephanie Price. Duneski seeks to proceed in form of papyrus, IFP, under Section 1915. The court is granting Duneski IFP status, but is dismissing her complaint for lack of subject matter jurisdiction pursuant to Section 1915E2, which is the short circuit mechanism in Section 1915. I mean, she'd have money to pay the filing fee if those damn, tech companies would pay her living expenses while she sues them. It's Facebook and Shitter's fault that she can't afford the filing fee. If she weren't so busy suing everyone, she'd be able to get a job. But, So, and because Duneski has filed at least 13 lawsuits in this district in form of papyrus, many asserting claims arising from a child custody dispute and several which were dismissed as frivolous, the court is enjoining and restraining her from filing any new actions concerning the same matter in this district without first seeking and obtaining leave by the presiding judge. Okay, so concerning the same matter, so maybe the lawsuit against Team Skeptic and the lawsuits against Shitter and Facebook and everything don't count. And Fletcher boy, thanks for being here. Enjoy your gig. Enjoy it. I'm kind of jealous. But so she can't bring any more child custody suits without seeking leave, and leave will not be given. So yeah, it's wild. Courts don't like wasting their time. So under Section 1915E2, a court must dismiss an IFP action if it determines that it is frivolous or malicious, fails to state a claim on which relief may be granted, or seeks monetary relief against a defendant who is immune from such relief. A complaint is frivolous when it lacks an arguable basis in either in law or in fact, or both. And that's Knightsky versus Williams. Moreover, federal courts are always under an independent obligation to examine their own jurisdiction. And federal courts may not entertain actions over which they have no jurisdiction. In fact, a federal court must dismiss an action at any time when it concludes that subject matter jurisdiction is lacking. How many times do we hear sovereign citizens, I can challenge jurisdiction at any time? Courts, if at any time they realize they don't have jurisdiction, have to dismiss, even on their own. So when a court lacks subject matter jurisdiction over a claim, it must immediately dismiss not just that claim, but any pendent state law claims as well, no matter how late in the case the district or appellate court identifies the jurisdictional defect. So, yeah, if the court, let's say the federal district court thought it had jurisdiction, if it goes all the way up to the Supreme Court and the Supreme Court says, hey, so we don't have jurisdiction, like there's no actual federal question here, no jurisdiction, this has to be dismissed. Why did this come up to us? But it could also be that the court had jurisdiction for some reason at the beginning of the case, but by the end lost jurisdiction. So it would be dismissed even by a court of appeals. So let's say it was brought under diversity jurisdiction and the plaintiff was asserting damages in excess of $75,000. Now, the thing is, if it's a sum certain, like if you know you suffered $20,000 worth of damages, you can't say, yeah, it was over $75,000. But like with defamation, it's hard to quantify defamation. So you're going to say, yeah, it's over $75,000 damages because, you know, it's impacted my future earnings. And that's obviously more than $75,000 for the jury to decide. But let's say you're in a car accident with someone who lives out of state and it causes damages and you sue before you take it to the body shop. And yeah, Lexus, which cost me $100,000, therefore federal jurisdiction. And you take it to the body shop and get a estimate and they say, so yeah, this is just a little scratch. It's going to take about $200 for us to buff that out. You now have a sum certain of $200 worth of damages, not $75,000 of damages. So on this new information, the federal court has lost jurisdiction. So if they learn that, they have to dismiss. So courts must read pro se complaints liberally and accept a plaintiff's allegations as true unless they are clearly irrational or wholly incredible. And you'll notice these aren't Twombly or Iqbal. These are older than Twombly and Iqbal, but they're sort of companions still. They're same area as Twombly and Iqbal. So even reading Duneski's present complaint liberally, the court finds it to be frivolous. Although Duneski provides scant facts in her complaint, it is apparent that her claims against Price arise from the removal of Duneski's children from her custody and the award of custody to the children's father. As discussed in the other cases Duneski has filed, those custody proceedings were conducted in state courts in Michigan and South Carolina. See all these cases. The court surmises that Duneski is claiming Price made statements or took actions that supported or assisted in the removal of Duneski's children. There is no indication in the complaint that Price is a state actor to support liability for constitutional violations under 1983. And footnote 1, the conclusion that Price is a non-state actor is further supported by the fact that Duneski has an identical action pending against Anthony Price, who is identified as living at the same residential address as Stephanie Price. Also filed May 23rd, 2024. So he filed presumably against husband and wife, presumably for the same actions, or at least actions arising out of the same transaction or occurrence, namely the child custody case. So she filed separate actions against them. It should have been brought against them as co-defendants, except it shouldn't have been brought against them at all because it's frivolous. It is well established that a citizen is not subject to Section 1983 liability simply by providing information to law enforcement. That's Wesser versus Goodson, 6th Circuit 2020, which held that even deliberate lies to law enforcement do not subject a private individual to liability under Section 1983. Also, Moldovan versus City of Warren, 6th Circuit 2009, providing information to the police, responding to questions about a crime, and offering witness testimony at a criminal trial does not expose a private individual to liability for actions taken under color of law. To the extent Price was a witness in any of the child custody proceedings, she is entitled to absolute immunity. That's true. See Briscoe versus LaHoo, Supreme Court, which concludes that Section 1983 does not abrogate the common law absolute immunity of all witnesses from damages liability for their testimony in judicial proceedings. So Section 1983 also doesn't apply to Facebook or Shitter or Team Skeptic or me or, it's against government actors acting under the color of law. So, yeah. So Duneski's complaint does not suggest any other basis for federal subject matter jurisdiction. It is therefore subject to dismissal under Section 1915E2B. As indicated, this is not Duneski's first IFP action, which was dismissed under this section. Several prior actions have been dismissed as frivolous. See all these other cases. Duneski has filed 8 IFP actions in May 2024 alone. I mean, she's working her way up to that frivolous litigator that I covered, can't remember his name, that sued every celebrity he could think of and basically wrote legal fan fiction and submitted it as, lawsuits. Can't remember his name. But remember, I did a video on it a while back. It's titled something like, "This is what a real frivolous litigator looks like," something like that. So if you haven't watched it, do, because it's hilarious. Proceeding IFP is a privilege, not a right, superseded by statute on other grounds as discussed in In Re Prison Litigation Reform Act, 6th Circuit 1997, and others. So the 6th Circuit has held that district courts may properly enjoin, so put an injunction, vexatious litigants from filing further actions without first obtaining leave of court. And the 6th Circuit expressed that it sees nothing wrong with an order that restrains not only individual litigant, an individual litigant from repeatedly filing an identical complaint, but that places limits on a reasonably defined category of litigation because of a recognized pattern of repetitive, frivolous, or vexatious cases within that category. There is nothing unusual about imposing pre-filing restrictions in matters with a history of repetitive or vexatious litigation. While an individual may not be absolutely foreclosed from initiating an action in a court of the United States, it is permissible to require one who has abused the legal process to make a showing that a tendered lawsuit is not frivolous or vexatious before permitting it to be filed. Janeski has filed numerous lawsuits in the Eastern District of Michigan related to the state court's child custody determinations. She has unsuccessfully sued the father of the children, judges and attorneys involved in those proceedings, and law enforcement. She now seems to be pursuing private individuals who were somehow involved in the proceedings or have shared information concerning the matter. She is abusing the privilege of proceeding IFP by filing frivolous lawsuits. Accordingly, it is ordered that plaintiff's application to proceed in forma pauperis in this action is granted, but her complaint is summarily dismissed as frivolous pursuant to Section 1915E2B. It is further ordered that any appeal from this decision could not be taken in good faith, and therefore plaintiff may not proceed on appeal in forma pauperis. So basically, it's saying so it is further ordered that plaintiff is enjoined and restrained from filing any new action in the United States District Court for the Eastern District of Michigan that arises from or relates to the custody of her minor children without first seeking and obtaining leave of court by the presiding judge or paying the full civil case filing fee, currently $405. The clerk of court shall not accept any filing as a miscellaneous action to avoid this requirement. Any request to file a new action must not exceed 5 pages and must contain a concise explanation of the facts and legal basis for the proposed action. A copy of this opinion and order must be attached to the request. So ordered, Linda V. Parker, U.S. District Judge, dated May 31st, 2024. Wow. Wow. That was a journey. And I said that's the last document we're reading, but just scrolling through Pacer, like I said, Janeski versus Price, filed May 23rd, 2024. Janeski versus Team Skeptic, filed the same day in the same court. Duneski versus FBI. Damn it. I kind of want to read that one, but we won't. We won't. If it's funny enough, we might do it later, but not today. Filed July 21st, 2023 in the same court. Duneski versus 22nd Circuit Court, Washtenaw County. Same court, July 24th, 2023. Next page. Not her. So, yeah, that's just the thing is, I realize you're here to help me make bad choices, but 3 hours and 25 minutes is about my limit for today. So I might do it later, just not today. If it's funny enough, Judge Simpson is in the district court in Washtenaw County. Judge Washington is in Washtenaw County. Couple others. Judge Frushour is Washtenaw County. So yeah, that's where I'm leaving it for today. That was wild. Remember, Miss Duneski, my name is Schlitzenheimer McGillicuddy, and so is Team Skeptics. We can be served at 123 Fake Street. Leave the complaint on the table next to all the fireworks. And yeah, just friendly reminder to Miss Duneski, you're going to lose your lawsuit against Team Skeptic. If you sue me, you'll lose. I haven't defamed you. I have only publicized your actions. I have not defamed you. You're not as good at the law as you think you are. Frankly, I'm better at the law than I think I am. It's that imposter syndrome thing. Watching Judge Simpson's court, you might be onto something. There might be something in the waters in Washtenaw County. And yeah. So with that being said, I am tired. I am going out tonight. That's why I usually don't stream on Saturdays. It's the day I go hang out with friends in real life, not just with online friends. And at some point I will make finance videos. The ad rates for those are super high. But yeah, so do the YouTubey things, like, share, subscribe, bribe your friends and family to do the same. Like and subscribe, do all the same stuff with Team Skeptic, although I know all of you are already subscribed to Team Skeptic. As I said, as punishment for him spending time with family today instead of joining us here, leave comments on his most recent video saying Happy Father's Day, Schlitzy. And, for those of you watching the Reed trial, I'll see you bright and early Monday afternoon. For the rest of you, I will see you another time. Probably getting caught up on other stuff. So thanks for joining me. Have a great weekend. Have a great Father's Day for those of you in the US. And yeah, so bye-bye.